Good afternoon, and may it please the court. My name is Megan Lane, and I, along with my co-counsel Karen Copeland, represent the defendant, St. Francis Hospital, and Kirsten and Norris Chapman. Mr. Francis is here, who represents the defendants, the urology group, and Dr. Zachary Kaur. He will be prepared to conclude the defense argument today.
Have you determined a division of time?
Yes, Your Honor. I'm going to attempt to take about 10 to 12 minutes of time.
Well, 10 or 12, which we're going to take?
We'll do 12 minutes, Your Honor.
12 minutes, okay.
And then Mr. Francis will take the remainder.
All right.
And we will not reserve any rebuttal.
All right. You may proceed.
Thank you, Your Honor. I will take about 12 minutes to explain why the evidence in the record here does not support the trial court's findings that extraordinary circumstances existed to excuse this envelope stuffing mistake that was made 65 different times over the course of 26 days when the mistake was made by counsel's staff. Unless Your Honors want a brief recitation of the facts, I'm going to proceed with the argument. May I proceed?
Please.
All right. Tennessee Code Annotated 2926-121B provides that a trial court has the discretion to excuse compliance with Section 121 for extraordinary cause shown. The term extraordinary cause is not defined, but our Tennessee Supreme Court has stated that extraordinary is commonly defined as going far beyond the ordinary degree, measure, limit, very unusual, exceptional, remarkable. The Tennessee Supreme Court has also provided us with some examples of what may constitute extraordinary cause. Those circumstances, the Tennessee Supreme Court has said, are illness of the plaintiff's lawyer, death of the lawyer's immediate family, or illness or death of the plaintiff's expert in the days before the filing becomes necessary. Whether a plaintiff has demonstrated extraordinary cause to excuse compliance with the statute is reviewed. It's a mixed question of law and fact, and the review is de novo with a presumption of correctness applying only to the trial court's findings and not to the legal effect of those findings. To be clear, the defendants are not challenging the trial court's findings of fact. We are challenging the trial court's decisions regarding the legal effect of those findings. A trial court abuses its discretion when its ruling is based on a clearly erroneous assessment of the evidence that is in the record. The trial court's decision here necessitates reversal. There is no evidence in the record to connect how the circumstances that were pled by Mr. Wages affected his mental ability to ensure that his office staff properly stuffed 65 envelopes. A connection between his circumstances and the error must be made as conclusively established by this court in the Hawkins case. Despite the lack of evidence of a causal link here, the trial court found that the totality of the events pled by Mr. Wages in his affidavit contributed to his ability to be mentally ready to recognize that the HIPAA releases were not correctly stuffed in the proper envelopes. There's nothing in the record to support that finding. We had no expert opinion regarding his mental or emotional state during the month of July 2020, which is when the notice letters were sent out. There was no testimony via affidavit from Mr. Wages that would show how any of the circumstances he pled actually impacted his ability to ensure that his office staff properly stuffed envelopes. Even after about 3 months from July 2020, when the mistake was made, the oversight was made again when Mr. Wages attached all the notice letters to the complaint that he filed. He made the mistake again when he executed his affidavit, which attested that the notice letters contained HIPAA compliant releases that allowed each provider to obtain the medical records from the other providers, which in fact that was not the case. The HIPAA authorizations that were included in each of the providers' notice letter only allowed them to disclose their records. They were not allowed to obtain records from the other providers that were given notice. We can all certainly agree that the pandemic was unique and an extraordinary event on its own, but the stress and the certainly fear of contracting the virus in early or mid-2020 was not unique to Mr. Wages, and it cannot be extended to establish precedent that any lawyer who is faced with a notice deadline in early or mid or late 2020 can be excused from complying with the statute due to that stress. We're also suggesting that the trial court erred when it weighed the totality of the circumstances. The trial court focused its determination on the circumstances pled by Mr. Wages in its affidavit, which were all the stressful circumstances that Mr. Wages pled he was under at the time. What the trial court failed to do was appropriately weigh the circumstances and the things that Mr. Wages was able to do and do correctly at the same time. Mr. Wages was able to meet with his client, who was able to decide to take the case that he thought it had merit. Mr. Wages reviewed the medical records that he received from his client in order to identify the potential defendants. Mr. Wages performed an investigation and reviewed those records to identify the potential defendants to which he wanted to provide notice to. Mr. Wages was able to draft and timely mail notice letters to 14 potential defendants. From those providers, Mr. Wages then narrowed it down. He made a decision that from those 14 providers, he wanted to file suit against 4. He was able to do that and do that appropriately. Mr. Wages was then able to draft and file an eloquent and appropriate complaint, setting forth his allegations against those 4 providers. Mr. Wages executed an affidavit of compliance and had that filed. Mr. Wages executed a certificate of good faith, certifying that he has consulted with an expert who believes this case has merit. He executed a certificate of mailing, and he filed that with the court. Mr. Wages was then able to properly serve and issue a summons to the hospital, serve and issue a summons to Nurse Chapman, serve and issue a summons to the urology group, and serve and issue a summons to Dr. Kaur. Most importantly, the record reflects Mr. Wages was a sitting judge throughout this entire time period that he's now asserting to this court he was under such crippling stress that he couldn't properly stuff an envelope. He was making judicial decisions for the city of Millington throughout this entire time. All of these things Mr. Wages was able to do and do successfully. Except now he wants to assert that he was under such stress that he was unable to catch the mistake made by his office staff. What this is exactly how plaintiff identified it in his response to our motions to dismiss. The first line read, "This is an envelope stuffing mistake." This was an oversight which was not caught or corrected with the second round of notice letters that went out, the third round of notice letters went out, or the fourth. And it was not caught again when he filed the complaint and attached every one of those notice letters to that complaint. And it was not caught when he executed his certificate of mailing, where he attested that the HIPAA releases that were attached to the notice letters were compliant with the statute. This is a classic case of attorney oversight or mistake, just like the Hawkins case, wherein this court held an attorney oversight without some connection to the attorney's mental or emotional state does not rise to the level of extraordinary circumstances to excuse compliance with the statute.
But in the Hawkins case, the trial court found that the plaintiff failed to show extraordinary cause. And in reviewing that case, the Court of Appeals says that the party attempting to set that aside has a heavy burden because the Court of Appeals has sort of a limited review of that decision as an abuse of discretion. Why in this case, where the trial court says that it amounts to extraordinary cause, would we, on review, overturn that, since you have a heavy burden to show that it should be overturned?
Sure, it is a heavy burden, and the discretion is not without limitations. The trial court still has to follow the legal and procedural framework that has been implemented by the legislation and the courts. And in order to review whether or not extraordinary cause exists, you have to determine whether the factual determinations fit within that legal framework. And in the Hawkins case, like Your Honors just suggested, the plaintiff in that case has testified almost identically with what Mr. Wages' affidavit states. And in that case, the attorney stated that he was normally meticulous with the way he provides pre-suit notice, which is almost the identical language that was included in Mr. Wages' affidavit. And that but for his military situation, the mistake would not have been made, which is almost identical to what Mr. Wages said. But for my stress due to COVID and some other situations, the mistake wouldn't have been made. And the Court of Appeals in Hawkins found no extraordinary cause existed because there was no evidence of the effect the circumstances had on the attorney's mental or emotional state, or how it affected counsel's ability to attend to the detail of pre-suit notice. So that's exactly what we're suggesting here. The trial court abused its discretion when it failed to weigh the totality of the evidence that is in the record. There is no evidence that would show how the stressful situations that were pled by Mr. Wages in that affidavit had any impact on his mental or emotional state. And even further, there's no evidence that would show how his stress impacted his office staff's ability to properly stuff envelopes, or how that stress that he's pleading in July of 2020 bled all the way over to October of 2020 when he still didn't catch the mistake the second, third, fourth, fifth, or sixth time. So that's what we're suggesting to your honors, is that the trial court abused its discretion because it did not properly assess. It was a clearly erroneous assessment of the evidence when he failed to consider everything in the record, which includes everything that Mr. Wages was able to do and do well during the same time period that he is now asserting he was under so much stress that he was not able to properly stuff envelopes. And the question is not just, are these events extraordinary circumstances? This court in Hawkins, like your honor just pointed out, the question is also, do those extraordinary circumstances justify excusing compliance with the statute? In this case, the answer should be no, based on the evidence that's in the record, all of the evidence, not just the omissions, but everything he was also able to do effectively. Section 121B is meant to be used in situations of truly extraordinary circumstances, those that go far beyond the ordinary degree or measure. It is not meant to be used as a Hail Mary, a last-ditch effort to save a plaintiff's noncompliance with the statute when an attorney or his staff is unable to properly stuff envelopes. Thank you.
Thank you. We'll let them, yeah. There'll be no rebuttal.
Yeah, I just got that. I apologize.
That's all right.
Good afternoon. I'm Kent Francis, and Joe Clark and I represent the Urology Group PC and Dr. Zachary Kaur. Our brief was a joint brief, and I think Ms. Lane did an excellent job addressing the issues and presenting our argument. I don't have much to add, but I do think it's important to assess the totality of the circumstances when analyzing whether the stressful events in Mr. Wage's life excuse the noncompliance with the statute. Because after all, the trial court concluded that no individual reason listed constituted extraordinary cause, but that the cumulative effect of all the reasons did. And it's our position that the totality of the evidence and circumstances does not establish extraordinary cause to excuse the noncompliance. The evidence does not establish that the stress caused the noncompliance. In fact, the totality of the evidence shows a very active but faulty attempt to comply with the statute. It's important to note that Mr. Wages provided timely notice. He sent 4 separate rounds of letters out, and each one had the same mistake, for a total of 66 mistakes. Mr. Wages' office sent out hundreds of pages of documents during the pre-suit notice phase. Mr. Wages' office, according to him, stuffed the envelopes, and we have no evidence of how Mr. Wages' stress caused his office to make this mistake. And then procedurally, there's important procedural history. Despite all of these stressful events, the plaintiff did not argue extraordinary cause in response to the motion to dismiss. When the plaintiff finally did assert extraordinary cause via affidavit, that affidavit did not mention all of the stressful events going on in Mr. Wages' life. Mr. Wade has asserted additional events in a second affidavit. The factual and procedural circumstances show that the plaintiff tried to comply with the statute but simply fell short. There was a timely, active, systematic attempt to comply. And we are not disputing that the events listed in the affidavits happened, and we can even acknowledge that some of them might have caused stress. But presenting a list of events, of stressful events, should not create a blanket excuse for any non-compliance with the statute that might occur. The extraordinary cause provision should apply when the plaintiff can show how the circumstances cause the non-compliance so that the circumstances actually justify the non-compliance. And we don't have that here. The trial court's assessment of the totality of the circumstances was erroneous, and the court should reverse the trial court's decision. Thank you.
Thank you. All right, Mr. Smith.
Thank you. I apologize, I threw you for a loop. Good afternoon, Brian Smith here on behalf of the appellee. May it please the court. The trial court's discretionary decision, and Judge Armstrong, you hit on this, the trial court's discretionary decision to excuse noncompliance for extraordinary cause was not an abuse of discretion and should be upheld by this court. The court, and I think you've already mentioned this, but talked about this, but the Hawkins case lays out the framework for courts to decide, trial courts to decide, whether to excuse noncompliance for extraordinary cause. Trial courts have to weigh the entirety of the circumstances and determine whether extraordinary cause exists on a case-by-case basis. Courts have discretion, trial courts have discretion to excuse noncompliance with 121A2E for attorney oversight caused by unique and extraordinary circumstances. And that's exactly what Judge Stokes found in this case. Judge Stokes looked at all the circumstances, the totality of the circumstances, and he determined that in fact extraordinary and unique circumstances did exist, and he decided to exercise his discretion to excuse the noncompliance under 121A2E. Now, the trial court's decision to excuse noncompliance is reviewed under an abuse of discretion standard. As Justice Kirby now noted when she was on this bench, a party who seeks to show an abuse of discretion carries a very heavy burden indeed to try to get that overturned. And it will be upheld so long as it falls within a reasonable range or a range of acceptable alternatives. There's two ways for this court to overturn a trial court's discretionary ruling. Again, this court doesn't supplant its judgment for the trial courts, but there are certain circumstances where the court can overturn a discretionary ruling, but those are, first, if the trial court applied an incorrect legal standard. There's no allegation in this case by the appellants that Judge Stokes applied an incorrect legal standard. In fact, I believe I heard that they said that Judge Stokes did in fact apply a correct legal standard. They just don't agree with the outcome. The second way is to show that the decision of Judge Stokes was so far beyond logic and reason that it resulted in an injustice to the appellants. So that's the issue in this case, is whether the trial court's decision is based on logic or reason. If it is, then this court should uphold that decision. And if it's not, then you can overturn it. The plaintiff or the appellants try to get there by asserting that the plaintiffs did not allege or describe any circumstances that go far beyond the ordinary degree, that are measure, limit, or very unusual, exceptional, or remarkable. They say that there aren't, those circumstances do not exist. And while normally I don't go through a lot of the facts at this level, I think they are important to talk about. Again, in this particular case, there's a lot of discussion about COVID. And COVID was going on at the time. COVID was exceptional. It was unique, as Ms. Lane admitted. And in fact, this happened in June of 2020, which was roughly 3 months after the Supreme Court issued an order finding that there was a state of emergency in this state because of COVID. They shut down the court systems. businesses had shut down, people were at home quarantining, and so it was an extraordinary circumstance.
Mr. Smith, what is the exact problem that was caused by the stress, is what I think is what we're trying
Sure.
to understand. In other words, what exactly is the problem? Apparently, there were several mailings that went out, but what's the exact problem that arose here? I understand that,
Yeah.
that a release was sent out saying that the physicians could, and healthcare providers could provide their own information, but there was nothing indicating that they could get it from the other healthcare providers. Is that?
Well, that's a part of the motion that we contest that, and that's not up here. We actually, that's part of our, what we thought Judge Stokes actually did make a mistake on. We thought that we had actually argued at the trial court that it says have to provide HIPAA releases that allow the defendants to obtain the records. And the releases actually did allow the defendants to obtain the records. It allowed each defendant to release records to the other defendants. That was an argument that was made at the trial court. It wasn't, Judge Stokes ruled against us on that. We actually did ask for that to get appealed, but that wasn't part of what we're up here on. As I understood the argument, we're here strictly on the extraordinary cause issue.
It's kind of hard to take it all out of context, I guess. Is what I'm
Right.
saying. In other words, we're trying to put together what's the extraordinary circumstances that caused the problem. You have to know what the problem was.
Well, the problem was, well, and that's...
We know 4 mailings went out.
Right.
Obviously, something must have been left out or
No, actually...
I don't know. I'm not sure. I'm still not sure exactly what the problem was.
So the letters went out to each of the doctors. For example, Dr. Kaur got releases that allowed him to release all of his medical records to every other defendant. There's no allegation that the HIPAA releases, there was anything wrong with the HIPAA releases. There's no allegation that there was anything wrong with the notice. The allegation is that that since the releases only allow Dr. Kaur to release his records to the other defendants, that somehow the other defendants weren't able to obtain those records. We did make an argument that didn't make any sense to us, and it's in Mr. Wage's affidavit that it's kind of 6 or half dozen of the another. If the defendants were allowed to release the records, then obviously the other defendants were able to obtain the records. But that's the mistake. There's no allegation there's anything wrong with the HIPAA releases. There's no allegation there was anything wrong with the notices. The problem, they say, is that Mr. Wages sent HIPAA authorizations that only allowed Dr. Kaur or each of the defendants to release their records. It didn't allow them to obtain the records.
That's not a problem with the HIPAA release?
Well, it's an issue that we contested. We said it wasn't, and we said it was at least substantial compliance, but they say that was the problem. And so what happened is, in essence, with Mr. Wages, what the allegation is it was a collation issue, that Mr. Wages put the wrong releases. They allege that Mr. Wages put the wrong HIPAA authorizations with the wrong notice letters.
Well, did everybody get the same one?
No, everybody got authorizations that allowed them to release their records.
Own records?
Yeah, to all the other defendants.
Well, how would they know who the other defendants were?
There's a list within the notice letter that says these are all the people that are receiving a notice letter.
Okay.
And so
But it doesn't direct them to send the records to each of the other defendants? Is that the idea?
right. It doesn't, but it allows them to release their records to all the other defendants.
If requested.
If requested, right. And so that's why we say that, I think that we did substantially comply with the notice letter, the notice requirement, because we did allow the medical records to be released to every other defendant, but that's not in front of the court right now. But that's the allegation. That's what they're saying was wrong, is that instead of Dr. Kaur getting an authorization that allowed him to get records from St. Francis, the Dr. Kaur got a release that allowed him to release his records to St. Francis.
So I realize that it's not before us, but the trial court obviously addressed that and made a determination, apparently, that
He did.
that there was something wrong.
He did.
And so I guess what we have to determine is whether it was wrong just because it was negligent, or was it wrong because there was some because of these extraordinary circumstances.
Right. So, and I'll point.
Is that what we're trying to determine?
Yeah, I believe so. I believe, and whether or not Judge Stokes' determination that there were extraordinary causes and there was a link between those extraordinary causes that resulted in the mistake, whether that ought to be overturned. And I'll tell you, there's two, when you boil it down.
That's the problem.
Huh?
I think that's the link that maybe there's a problem.
Right.
We may have a problem.
And there's two things in particular, and if you'll look at Mr. Wage's affidavit, and there's two of them. I think probably the best explanation is in the second affidavit, and it's page 1863 of the record, paragraph 16. But to talk about again, to look at the totality of the circumstances, Judge Stokes has to look at all the circumstances. And so there was all this stress that Mr. Wages was under as a result of.
Mr. Smith, let me stop you for just a second. I understand all these things that Mr. Wages say was going on in his life. However, what did the court find about how any of that made the wrong releases go out? What findings did the court make about how any of that impacted what actually went wrong?
So the court determined that based upon all that the stress that Mr. Wages was under, that it prevented him from focusing on what was going on and catching the mistake that his staff made when they put these releases behind allegedly with the wrong notice letter.
And what was the role that he was unable to perform as a result of the stress? I mean, was there anything in the record about what role he actually played in any of that happening anyway?
The role would be oversight, obviously oversight of his staff. I don't know that it's spelled out that specifically, but there is his affidavit does say as a result of the stress that he was under. And just to answer your question, Judge Goldin, I think you're asking for what in particular caused the mistakes or the alleged mistakes. And there were two things in particular, I think. One was because of the delay in getting a review back from an expert, which was hard to do because the experts were under the same stress everybody was, probably more so than the attorneys in treating patients and their staff. And then there was this malware attack on his office where he was actually trying to set up remote workstations for his staff. He got everybody laptops, and then they were the victim of a ransom attack, which they took all Mr. Wages' files away from him. He didn't get those back until the first part of the mid part of June. And then there was this process while his staff was scattered, trying to go through to make sure that he had everything, to try to make sure that he had met all of his deadlines, to make sure that his clients weren't harmed, and all that was kind of a mess. And so it wasn't just COVID, it was COVID with all these other things going on. The ransomware, I think, Judge Stokes said that in his findings that not one of these factors would amount to extraordinary cause. I actually believe the ransomware attack in and of itself probably was a unique extraordinary circumstance that would have led to all of this, would have led to him not being able to. Because remember, what we've got is Mr. Wages in the office, his staff scattered everywhere else, not really able to be in the same room with each other. They're putting these things together. Most of the time, I know when these things go out, I review every single letter to make sure that everyone's with everything that it needs, and I have a checklist, and I go through, and this is, everything is in there that needs to be in there. I think that because of everything that was going on, because of COVID, because the office staff was scattered, because he was under the stress of trying to recover from this ransomware attack, where someone stole all of his files and trying to get all that back and clean that up, that he just missed the fact that his staff had actually put the wrong HIPAA authorizations with the wrong notice letters. And that's ultimately what led to
Was
the mistake.
it the wrong HIPAA authorization, or was it just a wrongly drafted HIPAA?
No, there's absolutely no allegation that there was anything wrong with the HIPAA. And I think in their brief, they actually say that the authorizations that were sent were fully HIPAA compliant. This is not one of those situations where there was a problem with the HIPAA authorization. I think they acknowledge and they admit that the HIPAA authorizations that were sent were fully compliant. They just alleged the mistake was they put them with the wrong notice letters. So But
Well,
again,
I'm not following that. Let me ask you.
Found it either.
So,
okay,
a HIP, the notice goes to Dr. Jones.
okay,
It allows him or her to disseminate all of their records to the other doctors receiving notices.
right.
But it doesn't allow Dr. Jones necessarily to look at his own records. Is that right? Is that how it was deficient?
Well, first off, we claim it wasn't deficient, but I mean, I think the allegation is, say, Dr. Armstrong got a notice letter, and
Okay.
it allowed Dr. Armstrong to release his records to Dr. Goldin and Dr. McGee.
Right.
Normally, I will say that normally what we do is when we send out these notice letters, we send Dr. Armstrong authorizations to get records from Dr. Goldin and to get records from Dr. McGee. It got flipped this time. So instead of Dr. Armstrong getting records to obtain records from Dr. Goldin, Dr. McGee, Dr. Armstrong got an authorization allowing him to release his records to Dr. Goldin and Dr. McGee, and Dr. Goldin and Dr. McGee got authorizations allowing them to release the records to everybody else. So our argument in the trial court was the net effect is the same. Everybody got the records, and so it shouldn't matter.
But in order for Dr.
My time.
Armstrong to get Dr. Goldin's record, I would know that he'd been sent a notice, but then I would have to do what?
Yeah, contact Dr. Goldin, but you would have to do that
But I
anyway.
wouldn't have to provide a HIPAA release because he already had the HIPAA release
Correct.
saying that he could release them to me.
That's correct. And that's why we argued at the trial court that there was substantial compliance, because the net effect was the same.
But the court found that it didn't comply with the statute, correct?
He did. He found that there was not substantial compliance because the HIPAA, that Dr. Armstrong did not obtain a release to get records from everybody else, which is unfortunately the way that these cases have ended up, these hyper-technical arguments that sometimes I think don't make a lot of sense, this being one of them, but
Could I look at my own records, what was sent me?
yeah, I think the court has already decided that. The Supreme Court has decided that there's nothing that prevents you from seeing your own records.
Okay, all right.
So, anyway, my time is up. Unless there are any other questions, I'm finished.
Thank you.
Thank you, Your Honor.
Thank you, counsel.
That's interesting.
May call the next case.